Well, Your Honor, I believe that we filed a parenting time complaint with some proposed provisions to eliminate some of the issues that have been ongoing.
Okay,
Subsequent to that, Ms. Ms. Huffman filed a change of custody very recently, which I have responded to, and do think that it's inappropriate to hear today. I think that we should be going before the referee to discuss the parenting time complaint and proposals for solutions. Thank you.
okay. Ms. Huffman, you are muted. If you want to unmute, and then go ahead.
Yes, would you like me to go ahead with my?
Yep, go ahead with everything.
Okay, so we did file a motion for change of custody, parenting time, and child support based on several reasons. First of all, we do have a change in circumstances, that being this child's need to start counseling, whereby she's never needed to have counseling before. Mom was sole caregiver of this child, then custody was changed not too long ago, and now things have simply gone downhill. And that's not just our side saying that, that's both sides saying that. The child is having issues in school. She's not being properly dressed for the weather on dad's weekdays. These things are documented. Moreover, dad is blocking mom, the cell phone blocking, so that it's sabotaging mom's communications with the child and with the father. He has this extreme need to control every aspect of the child's life, from ear piercings to haircuts, simple haircuts, to driver's training even. And just mind you, this child is 8 years old. The child has become extremely upset seeing quote, ugly ass bitch on her father's phone. Whenever mom calls or texts, that's what pops up. We are asking the court to set an evidentiary hearing in front of this court, and not to send it to the front of the court, but for this court to hear it. And in the meantime, order a psychological evaluation on father, and to order our family or my family wizard, whatever that's called, I can't recall it this time. Regarding defendant's motion, number 3 says it all, really. Per paragraph 3 says, since implementation of the current order, communication and teamwork have continuously gotten worse from pickup. So that's the change in circumstance, really. They admit to there being a change in circumstance. It says it's continuously gotten worse, communication and teamwork, from pickup and drop-offs to holidays, and almost every interaction having aggression and disagreement. So obviously there's a change in circumstance. We agree there's a change in circumstance, and this needs to be heard, and I believe it needs to be heard in front of Your Honor. Thank you.
Okay, thank you. Ms. Grantham, anything else?
Yes, thank you, Your Honor. I believe in paragraph 3, we give specifics on the continued parenting time violations. And we were specific on that because we're hoping that with the proposed reasonable provisions that it would not be ongoing. Most of what was just recited by Ms. Huffman is just with lack of better terms, a way to mislead this court, because I do believe we need an evidentiary, because we'll be able to prove what was just said was not true. There has not been a change in circumstances since the last order. If we look back at when we went before the referee, which then did change the custody, you'll see that all the things that that was mentioned were occurrences that happened prior to the last order. With that being said, currently, what we are seeing is just her inability to accept this change in custody. And despite all the efforts putting forth and trying to communicate, the provisions that we suggested are supposed to help her, and in communication. We actually asked for the family wizard. We asked for the tone meter. We asked that both parties be involved in all the decision making, but in a way that can be in the best interest of the minor child, and not using the minor child frustrate parenting time and the like. And if you look at the parenting time complaint that was submitted by defense, it specifically says that he gave her a phone, meaning the minor, asking if he can, be in contact with the minor. It was actually her that would not allow that. So most of what's being said is a deflection. So I do agree only in part that we do need an evidentiary hearing, but in regards to parenting time and the intentional violations of what was agreed upon in the order, and find solutions that this would not continue. So I ask that the motion that the plaintiff has submitted to court just recently, I think a week ago, be dismissed, because proper cause cannot be shown, or with regards to a change in circumstances since the last order. And so there's not even a reason to go forward in this, other than these allegations, which simply can't be proven in an evidentiary hearing. So I asked for an evidentiary hearing just to see if there has been a proper show or cause and circumstances to warrant the court to review a change in custody.
Okay, thank you. Well, what the court's going to do is, it does appear that reviewing the pleadings, hearing the argument, that the parties are not able to communicate at all. And so the court is going to order that the parties would communicate through our Family Wizard app. I will let the parties know that as you communicate through that, the court would have access to all of that communication. So, I guess I'd say take, reasonable, I guess you'd say, steps in this particular matter to know that the court will have access to that based upon what you may say or anything that may be reflected in the communication through that particular app. The court would order that the children would be allowed to use the phone that the defendant purchased for the child in this particular matter. The court does note that there's obviously a lot of allegations about issues concerning parenting time. The court will refer the issue of parenting time to the referee for a evidentiary hearing. However, as the court looks at the plaintiff's motion for change of custody, would only be with regard to circumstances after May 14, 2021. Based upon my reading and hearing argument today, the court does not believe that there is sufficient proper cause or change in circumstances to meet the Vivarka threshold for evidentiary hearing on the issue of custody, so the court will deny that. Guess I will ask Ms. Grantham, I'll ask that you would prepare that order and submit it under 7-day notice of entry. That will conclude this matter at 10:13 a.m. You're free to go. Have a good day.
Thank you.
Again, the court will note this matter is before the court on your petition for a personal protective order. I think my staff has talked to you that there is no proof of service on file, and apparently what you've stated is that you provided and made payment to the sheriff for service, and they were not able to serve. Is that correct?
Yes, sir.
Okay. What happens? You're going to have to find somehow to locate defendant for purposes of service, because obviously she has to be served before we can proceed. We can't proceed without her having notice of these particular proceedings.
Okay.
Okay. I mean, it's just that, due process requires that the party have notice of what they're required to defend. So at least they're required to have notice. So there
Well,
would be,
I gave her the phone number and I put everything down.
all that may be true, but if she wasn't served, we can't proceed. Okay. So you're going to have to get another address or something else. And then you can simply renotice. You don't have to file your motion again. You can just file a renotice of hearing and serve her. Well, you have to serve her with the original motion and the renotice to notice that you might want to put it out longer in advance so that you could have a chance to serve her as best you can. Do you have any contact with her at all?
Well, she texts me. I don't text her back, and she calls me every day. And I gave him the phone number. I don't see how they didn't talk to her, but like I said, I can't have nobody coming by my house and busting out my windows and stuff.
I understand all of that, but she still has to be served regardless of that. So
There's no possible way I'm gonna be able to serve her because one, I don't know where she at. Two, she might be out of town, and three, I cannot serve her face to face because
Well, but you could have a third party, you know, you don't always have to have the sheriff. You could have another third party that knows her that could get her served as well.
but I don't know anybody in North Carolina.
Okay, so she's in North Carolina.
Well, she said she was in North Carolina, and she said she was coming back in April to check on Trey. But
Well, what you can do is get a renotice after the April, you know, set it sometime in May, and get her served at that time. If she's going to attempt to have contact with the child, have a third party that could serve her at that time when she attempts to have contact with the child. And once you have service on her, then we'll be able to proceed.
okay.
Good afternoon to both of you.
Good
Okay,
afternoon.
thank you. I'll go to Ms. Huffman first. Ms. Huffman, tell me what's happening in this case and where are we at?
Thank you. So it's my understanding that the 180 days will be up on April 9th, that Mr. Vreeland will be noticing up a pro-con and entry of divorce shortly thereafter, or to take place shortly thereafter. So we would just ask for time to be able to do that.
Okay, do you have resolution in the case or what's happening? in that regard?
It's my understanding that she's been defaulted on the counterclaims, that she did not appear for mediation. It's my understanding that Mr. Vreeland did do requests for admissions. They were not returned, therefore deemed admitted.
Okay, I'll go to Ms. Infante. Ms. Infante, are you disputing or contesting anything in this case?
Can I have a translator on the Spanish translator?
Well, you can, but you're going to have to request that. There's a form that you have to fill out. You can get that from the clerk's office. We just don't have translators sitting around waiting, so that's something you're going to have to do and set up.
Oh, okay. So what are you saying? Can you repeat for me?
Yeah, what I'm saying is if you want a translator, you have to make a request for a translator because that has to be scheduled. As I said, we don't have translators just waiting in case somebody asks a day of a hearing. You have to request them in advance.
Mm-hmm. Okay. In this case, I want to give my house. I want to go back to my house, and I want the custody for my kids, for my 3 little kids.
Okay.
And
Okay, ma'am, hold on. There may be a number of things that you want, but you're going to have to file the appropriate paperwork so that the court can examine that and see, because effectively you haven't done anything yet. And as a result, you were defaulted. So you're going to have to seek to set aside the default and then file the paperwork requesting what you want in the case. So it'd probably advise you to consult with an attorney, even if you don't get an attorney, is to consult with them to find out what you need. Okay?
Okay.
What's going to happen is you'll be receiving paperwork from Mr. Vreeland with another date on it. At that point, you're going to have to request an interpreter prior to that date. And you should also file the other paperwork that you need to file before that date.
Okay.
Okay?
Mm-hmm.
Well, we'll end today's hearing at 1:37 p.m. You're free to go. Have a good afternoon, and we'll await Mr. Vreeland's scheduling of the pro-con. Mr. Umloff, have you had any communication with the defendant? And
I last spoke with her on February the 8th, 2023. Specifically, I spoke to her about the issue of the DNA testing that needed to be done. I provided her with a place in Kalamazoo where it could be done. She asked me if there was a place in Battle Creek, which is closer. I did not know of one. I told her I'd look into it and find out. I couldn't find a more local place in Battle Creek for her. So I called her on February 22nd of this year to tell her that I couldn't find one. She did not answer, so I left her a voicemail. She never called back. In reviewing this case this morning to prepare for this afternoon settlement conference, I called her again, and I heard an automated message telling me that she was not accepting calls.
Okay.
Mediation
Any
was,
calls or just yours, Mr. Umlauf?
I'm not sure.
Okay.
Mediation did not occur. It was scheduled for March the 1st. It did not occur because she did not pay the mediator in advance.
Do we have any other issues other than the paternity?
There is still, I believe, custody and parenting time for the minor child that is a product of the marriage.
Okay. Well, maybe what we'll do, because she hasn't appeared, she's required to appear at today's date. The notice provided that parties appear in person. So court would, at least as it relates to that children, would grant you a default. You can proceed with a default on that, notice it up, and maybe at that point we'll get her attention and we can proceed on the other matter as well.
Certainly. There is still, although the parties have been separated for a long time, property and debt related issues as well. I would request a default on those.
That's fine. I'm granting the default generally, so you can, because she hasn't appeared on any issues. And that'll allow you to proceed with, again, the entry of your default judgment. And all I'd say is maybe check if you could with Mr. Magnuson at the front of the court. I don't know if these parties would be entitled to go through there to get a DNA or not.
Okay.
It's possible. If they are, then we do have one in Battle Creek that we could utilize.
Okay. I will ask him.
Okay. Court will end this matter at 1:40.
Good morning to
PM.
both
You're
of
free to
you.
go. Have a good day.
Thank
Court will note this matter is before the court on the plaintiff's objection to the referee recommendation. Ms. Hopkins, when I reviewed that, there was said you had an attachment, but the objection that I had no attachment. So I don't really know what the basis of your objection is. So if you want to recite that, then we can proceed.
Yes. So I'm objecting to the recommendation that Julie Bradfield made on February 6, 2023, and I'm requesting a de novo hearing for a motion regarding custody. I initially filed the motion regarding custody on September 15, 2022, and a hearing was set for October 11, 2022. Mr. Hart did not go for the hearing because he
Excuse
claims
me,
he
Your
did not
Honor.
know of the hearing.
Yeah.
As I did.
Oh, hold on, Ms. Hopkins, you were
Yes.
breaking up there. So
Okay.
Your Honor,
yes.
An attorney.
my attorney's supposed to be here.
Oh, okay.
I just noticed that.
I didn't know that anyone had an attorney. So
Yes,
let's
Yes, Your Honor.
wait. Let's wait, Ms. Hopkins.
Okay. I'm requesting a de novo hearing for motion regarding custody. I initially filed the motion regarding custody on September 15, 2022, and a hearing was set for October 11, 2022. Mr. Hart did not show for the hearing because he claims he did not know of the hearing, as I did send him notice. An evidentiary hearing was set for December 5th, 2022, and during this time, Mr. Hart retained counsel, then filed a motion to have the hearing adjourned, in which it was granted. While this original motion was adjourned, Mr. Hart's counsel filed a motion to dismiss due to lack of subject matter jurisdiction to make pursuant to the UCCGEA. I feel that Michigan should have exclusive continuing jurisdiction to make child custody determinations pursuant to the MCL 722.1202 as the finding as a fact that my son has a significant connection, as evidenced by of all of Xander's maternal family resides in Michigan and both of his siblings live in Michigan. Also, I feel that my motion regarding custody is of great significance to my son's emotional well-being. The current order does not allow enough time with his siblings or myself. As stated by Mr. Hart's counsel, that I have not exercised my visitation is untrue. And indeed, I have exercised my visitation, and I have went above and beyond to obtain extra visitation, as I was present at Xander's baseball summer league twice per week. As I have asked to get more visitation, I was completely denied by Mr. Hart. And my mother, Linda Kramer, has asked many of times to get visitation as well, which has been denied as well. Xander has many of close relationships in Michigan, including myself, grandmother, cousins, and siblings. I'm asking the court for relief to keep jurisdiction in Michigan and proceed with the motion regarding custody.
Okay, so as you stated, Ms. Hopkins, your basis for jurisdiction, you said that the child has family and siblings that live in Michigan. Is that the extent of it?
Yes, and he's always lived in Michigan and been in my care. Yes.
Until when?
Until November 4th of 2021.
Okay. Okay, thank you. Ms. Bailey Hobbs, what's your response?
Thank you, Your Honor. First, I'd like to object to Ms. Hopkins' objection, as it does not comport with MCR 3.512E4, which requires a clear and concise statement of the specific findings or application of law to which an objection is made. Ms. Hopkins has made a general objection to the referee's recommended order. However, she did not include any specific finding that she particularly objected to. Should this court move forward with finding on the subject matter jurisdiction regarding Ms. Hopkins' motion, I would argue that the minor child does not have a significant connection with Michigan per MCL 722.12021A, as further explained in our motion. The case White v. Harrison White, 280 Mich. App 383 from 2008 makes it clear that in order to satisfy the second prong of MCL 722.12021A, which is the significant connection requirement, the parent living in Michigan must maintain a meaningful relationship with the child, and in doing so, that parent must exercise parenting time in Michigan. Plaintiff had not exercised parenting time in Michigan at the time of this referee hearing. After the referee hearing on February 18th, plaintiff mother brought the minor child to Michigan and had the minor child sit in her car or play in her front yard for 2 hours, as she knew that our argument was that she had not had any parenting time with a minor child in Michigan for over 15 months. I would also argue that there's not substantial evidence in Michigan. All substantial evidence regarding Xander's life now is in Indiana, from doctors to sports teams to school and friends. As all evidence relevant to those issues is located in Indiana, it would be extremely difficult to subpoena all of those people to testify at a hearing regarding custody in Michigan.
Yes. So I know this matter is, I feel like it's a difficult process to determine custody and or what's in the best child's interest. I initially Xander was supposed to return home a few weeks after the 4th of November in 2021. He did not come home due to a filing of an ex parte motion regarding custody, and I was not allowed to speak nor see my son. So 0 contact did Mr. Hart allow me to have with him. And I feel like the best interest of Xander has not been considered, as I feel that Xander should be able to express his feelings and be given the option to speak of where he would like to live. The time that has passed that is lost cannot be made up. Or recovered. So also to mention his time with his sister and maternal grandmother, aunts, uncles, and cousins. And now as of now, both of his siblings live in Michigan. And he has minimal contact due to the fact that I only have minimal amount of time on every first and third Saturday to see my son. It's a 3-hour one-way drive and a 3-hour back. So he had 2 hours in Michigan to see his siblings and to drive back. So a total of him being in the car for 6 hours total is kind of unheard of for a child to sit, but that's what he wanted to do. And, he wanted to see his siblings so bad. And it's a 12-hour total drive for myself, regardless of the weather. That would add more time onto the traveling. And I feel like it would be fair to give Xander that chance to talk and to express his feelings on this and be able to call me at any point in time. I only get every Wednesday at 6 p.m. to talk with my son. And sometimes I'm at work. I work 12-hour shifts, so that cuts into my shift. So I plan on taking my break at 6 o'clock. But my daughter is not available to talk with him every Wednesday. And I try to incorporate that every time, but it's impossible. So with this said, if a decision cannot be made right away, I feel like to grant custody in my favor, could I possibly increase my visitation, respectfully in Xander's best interest?
Okay. Okay, thank you. Well, in reviewing the pleadings and hearing the argument today, the court again, has Ms. Bailey Hobbs has pointed out, there's been no specific allegation that the referee made a factual or legal error, simply that argued that the child has, again, significant contacts with Michigan because he has family and siblings that live in Michigan. But the court will note that, again, the amount of parenting time has been minimal. Apparently had not had the child in about 15 months. And again, there were, no additional evidence presented as to any error that the referee made. So what the court is going to have to do in this particular matter, I'm going to deny your motion, ma'am, as the court does not find that the referee made any factual or legal error in this matter. It does appear as well that, again, as the child has been in Indiana for, since November of 2021, that is the home state of the child, and it would be that is the state where by the significant contacts would occur for purposes of a hearing. And so the court is going to again order that would be the appropriate jurisdiction in this particular matter to proceed. Should you want to proceed, Ms. Hopkins, you have every right to proceed, file those motions, but you need to file it in the appropriate forum. So the court will deny your motion at this time and conclude this matter at 10:40 a.m. You're free to go. Court will note that this matter is before the court on the plaintiff's motion to enforce judgment of divorce. The basis under the motion is that defendant has refused to abide by either the court's determination or verbal agreement that the parties as it relates to tax exemption. Is that the gist of it, Mr. Chadwick?
Yes, sir.
Okay. Anything else that you'd like to add?
No, not really. That's pretty much the whole of it.
Okay. Well, the court notes that the judgment of divorce in paragraph 19 does provide that the parties would alternate the deduction, with the plaintiff claiming in 2021. And you're saying that, Mr. Chadwick, that there was some verbal agreement different than that. Is that correct?
Oh, yeah. I went to claim him last year as per my year, and she had already claimed him. And then when I spoke to her, she said her tax preparer told her she had to claim Orrin that year. And then based on the conversation we had, she said that I would just claim him the next 2 years. And then basically the same thing happened again this year.
Okay. Well, I will tell you, what the tax preparer may say has no influence or impact upon the court, because the court will only enforce court orders. We don't enforce what some third parties say. And the order, it appears to me, and you can correct me, Miss Chadwick, it says that under the judgment of divorce, that again, Mr. Chadwick would have 2021, and then you would alternate each year thereafter. So Mr. Chadwick, she would have 2022 unless you can, do you read the judgment differently than that?
No, I read that exactly how you said, but we verbally agreed when she had claimed him last year, which was my year, that I would claim him the next 2 years, and then there we go.
Okay.
And
Okay, Ms. Chadwick, is it correct that you claimed in 2021, which would have been Mr. Chadwick's year?
Yes, it is. And
Oh.
I called him as soon as I did, and I offered to give him the money. I wasn't doing it for the money. I did it because I thought it was going to mess both of our taxes up.
Okay,
It-
well, let me
don't
tell
know
you,
what-
you've got to comply with the orders, and if the orders say you do something in a particular year, that's what you do. You can't just unilaterally decide, oh, you can bring it into court if there was a issue with that first year. You could have brought the matter back into court, and we could have potentially have changed things, or again, at least discussed it at that particular time. But you can't change the judgment of divorce just because you choose to do so.
No, I understand. And
Okay.
I called him immediately when I did it,
Okay.
and I offered to give him the money for it. I just didn't know at the time that I thought I was doing the right thing at the time.
Okay, well, what the court's going to do is based upon what is stated. The court will order that Mr. Chadwick does have the right to claim the child for year 2023 and 2024. And then, Ms. Chadwick, you get 25, and that'll put us back on an alternating yearly basis after that. So, Mr. Chadwick, what you're going to have to do, you're going to have to prepare an order which will recite that. You can submit it to the court under a 7-day notice of entry, but you'll have to get it in within 7 days. So if you wait beyond the 7 days, then you're going to have to notice your order up for entry. Okay?
yes, sir.
So just prepare it that would state that you have a right to claim the minor child for tax years 2023 and 2024, and then the parties would alternate thereafter on every other year.
Yes, sir.
Okay, thank you. The court will end this matter at 10:46 a.m. You're free to go. Have a good day.
Thank you.
Thank you.
Can you hear me, Tiffany?
Yes, I can hear you.
Perfect, okay.
Court will note in this matter that the matter is before the court on the plaintiff's objection to referee recommendation. Ms. Egan, when you are again objecting to the referee's recommendation, you can't object just because you don't like the results. You have to show whether the referee made a factual or legal error sufficient that the court would set aside that particular order. So what is the factual or legal error that you believe that the referee committed?
I believe that when the referee put James's support at 0, he made an error because James said that he was not trying to find any other work. And his doctor note was only for his construction business that he was running. It wasn't for, anything else. And when I asked him if he had tried to find another job or any other type of employment, he said no, that he had not.
Okay. And that may be, but the referee can still, again, take that into consideration and extrapolate that to anything else. So if he has doctor's notes that say that he's not able to work, they can, again, infer that he's not able to at that particular point. So I guess I'm just asking again, what was the error that the referee made? You may think, well, geez, because he didn't do this, but again, the referee can extrapolate what they have to those other circumstances. You get, so what I'm saying is, if he can't work construction, he doesn't have to, the referee doesn't have to go through and say, well, he can't do this either, and he can't do that, and he can't do that. They can simply generalize that to, well, the person is not able to work at that particular time. So,
Okay.
well, if you have anything else, let me know.
It was just mainly that he said that he wasn't, trying to find any work. And I understand what you're saying. I just assume that the doctor's note is only based off of his current employment at the time, which was construction, which is far more, strenuous than driving or standing.
Right.
So,
but if the doctor says that he's not able to work at that particular time, the referee can accept that. And what I would probably do at this point, Ms. Egan, you haven't established any basis to set aside the referee recommendation. Doesn't mean that you can't. I don't know the date of the order specifically, but it doesn't mean that you can't, in a year, file a motion at that point to have it reviewed. And, maybe circumstances have changed, or at least at that point, you can get, updated medicals or anything of that nature as well. Okay? Okay. Thank you. The court will end this matter at 10:50 a.m. You're free to go. You have a good day.
Okay.
Calling case 2017.
Court will note that this matter is before the court on the defendant's motion to set aside referee recommendation. Mr. Robinson, it looks like from what you've said, and I'm quoting, you say in your objection, you say you don't feel that $138 a month for child support is appropriate.
Yes, sir.
Okay, why is that?
Because before this, me and Chantel had an agreement that I would get him 1 week and she will get him in 1 week. And she haven't found a job, so she hasn't been working and wasn't able to take care of Trey. So I'm losing 13 hours every 2 weeks because of this situation. My boss helped me out. She takes him to school. I have to bring him to work to even get hours, and she helped me take him to school. And I just got a teeth fix. It was $500 to get his teeth fixed. I pay for all his clothes. I pay for all his shoes. I pay for all the co-pays. I pay for insurance. And when I didn't have a job, they was charging me $400. So I believe $300 is fair.
Well, let me tell you, it's based upon income and the child support formula, not based upon just what you feel is fair. You understand that?
They told me it was based over overnight. She don't get no overnights. When I didn't have overnights, they was charging me $400 a month.
Okay. That comes into play, but it's not based upon that. Okay. It's based upon your income, and then they put it in the calculation. Your income, they put in the calculation, taking into consideration overnight. So if she doesn't have overnight, but I guess what I'm asking is that what error do you believe that the referee made? You're just saying, I don't think 138 a month is fair. That doesn't mean anything.
No, not when I'm losing 13 hours every 2 weeks because of her. So I feel like I should be able to get a little bit more extra because I'm losing all these hours at work, and it's kind of hard right now to support both of us because of these hours I'm losing.
I understand, but you still haven't pointed out that any factual error that the referee had made. You're just saying why you feel that it should be that way, but you're not saying, okay, for instance, let's say you had income and your income was, I'm just throwing a figure, let's say it was $650 per week, but the referee got it wrong and they said that it was $560. They juxtaposed the numbers. That would be a factual error. And, or if they cited let's say they cited that the overnights were different than what they are, or whatever, that would be a factual error. You haven't pointed out any factual error that the referee had made.
Well, he told me it goes by overnights, and I'm just losing a lot of money because of the situation, and I don't believe $138 is appropriate because, like I said, I pay for everything.
Well, you do have a right if she's not paying for things that she should be paying for. You have a right to file a motion and seek reimbursement from her. So for instance, on medical, your judgment and everything you have would have a breakdown in the medical division. You have a right to come in and say, look, I'm supposed to pay blank, whatever. I'm supposed to pay 60%, she pays 40 or vice versa. And you'd have a right to order that she would pay and reimburse you for those medical expenses. But so far, you haven't pointed out anything that the referee made a mistake on that the court should set aside that particular order. And that's all I could do.
Okay, because I thought this was for me to get more child support. I didn't know you had to have factuals and
Yes,
all of this stuff. And
you do. You have to have a factual basis for what the referee did and what any error that you're claiming that they made. And you haven't done that. I mean, you just say, well, I don't think it's fair. It's not appropriate.
okay, so why were they charging me $400 when I didn't have a job? And I don't think $138. We cannot
Okay.
survive off $138, and she's still not even working.
Okay, what happens is we're where we are now. I can't speak to the 400 and when that happened, if it was 3 years ago, 5 years ago, whatever. That's not before me today. The issue before me today is 138 a month.
Yes.
Okay. And again, you haven't pointed out that the referee made an error, and as a result, I can't change it unless you do that.
So how do I need to get more child support? I need to bring in receipts from clothes, or
No,
what do I
no,
need to do?
no, what you'd have to do is you'd have to show, you would have to file a motion to modify child support. And you would have to have a legal and a factual basis for doing it, meaning change in income, things of that particular nature. Those would be a basis to do it, change in the child support formula, et cetera. But there's just nothing that you've presented today that would allow me to deviate from what the referee had done. So,
Well, she has no overnight, so that doesn't calculate for anything.
yeah, it comes into play, but the referee would have considered that in making its calculation. If you look under the child support calculation that would have been attached to the referee's determination, they state in there what the overnights are.
Yes.
And so you'll have to look that and check that out and see. But it's based upon the order as well. So the referee is constrained by the order. If it gives her particular time, if she gives her, I don't know, 90 overnights, which is the standard, and she doesn't take them, then you have a right to seek modification on the basis that she doesn't take the overnights, and that therefore it's different. But you're gonna have to file a specific motion for that and file it, not simply come in and object to the referee recommendation. So, court will deny the motion at this particular time. We'll end this matter at 10:58 a.m. You're free to go. Thank you, sir.
Okay, I have another court date, so should I just stay on here?
Not. Oh, I see. It's the other motion. We'll put you in the waiting room, bring you out. Schaefer on behalf of the
Okay.
plaintiff, and Miss Elaine on behalf of the defendant. My understanding, Mr. Schaefer, this is your motion to show cause for makeup hearing?
No, I believe it's the other way around.
Okay. Well, I'm sorry, I didn't have it identified on my notes, so for some reason, I thought that was that way. So, Miss Elaine, are you ready to proceed?
I am, Your Honor.
Okay, Mr. Schaefer?
Ready, Your Honor.
Okay. Ms. Elaine, do you wish to make an opening statement or simply proceed to proofs?
A very brief one, Your Honor.
Okay.
Your Honor, what you will hear about today is the fact that the parties have a provision in their final custody order relating to parenting time that Mr. Tabaka would exercise when Ms. Tabaka was working. They exercised and operated under that provision successfully, routinely, and consistently for 6 years, up until there was a precipitating event in June of 2021 that angered Ms. Tabaka, made her frustrated with Mr. Tabaka, and at which time she decided to vindicate herself by refusing to abide by the extra parenting time provision any longer. So the children in this case, Madeline and Daniel, went from a situation where they saw their father every single day during the school weeks and every single day during the summer, other than when Ms. Tabaka had her regular parenting time and was not working. So very regular, almost daily contact with their father and his involvement in their schooling and activities, to cutting all of that out literally overnight and abruptly. The kids have suffered tremendously from that. Mr. Tabaka has tried to work this out with Ms. Tabaka directly. He has pleaded with her to reinstate the operation of that provision, and she has refused to do so. Not only that, Your Honor, but you will see that she manufactures excuses as to why she doesn't have to abide by that provision. She now, at this late date, offers unbelievable and incredible interpretations of that provision that were never heard of before this date and time, after she was show caused, and so forth. So we have her time records that will illuminate some of the untruths that Ms. Tabaka has proffered as excuses for why she would not allow Mr. Tabaka to exercise the parenting time. But those are what the proofs will show, Your Honor. She's deliberately and without good cause violated a court order, and Mr. Tabaka seeks 210 hours of makeup time, all of which can be demonstrated to this court today, of time that he has missed when Ms. Tabaka was working. And that is the relief that he seeks today for the show cause violation.
Okay. Mr. Schaefer, do you wish to make an opening statement or a reserve?
I do wish to opening statement, Your Honor.
Okay.
This order was from 2015. This order was put into effect for the purposes of dealing with the minor children when they were in preschool. And it was because Mr. Tabaka did not want to pay for any childcare during that time. The children have not been in preschool for some period of time. And this was trying to be explained to Mr. Tabaka at numerous occasions, but he has taken this order, which is really geared for the preschool time, and used it as a harassment tool against Mrs. Tabaka, and he continues to do so. In spite of the misinterpretation of the order by Mr. Tabaka, Mrs. Tabaka has complied with the terms thereof. And the order is subject to interpretation by the court, but the notes that are asterisk have to do with the times that the kids are in preschool. But in spite of that, my client has adjusted her work schedule to comply with the order. He has not been attentive to any compromise of dealing with this, but uses it solely for a harassment tactic against his ex-wife. As a result of that, Your Honor, my client is not in contempt of the order. She has followed the order, even though the order is arcane from the standpoint of time-wise. And there are other motions that are pending, including a motion to change the language of the parenting time. Your Honor, we were asking that this matter be decided in favor of Ms. Tabaka, and that reasonable cost and attorney fees be awarded to her. Thank you.
Okay, thank you. Ms. Elaine, you can proceed and call your first witness.
I call Alexis Tabaka.
Okay, go ahead, Ms. Elaine.
Thank you, Your Honor. Ms. Tabaka, your attorney just made reference to you as an ex-spouse of Mr. Tabaka, but the two of you were never married, correct?
That's correct.
And you chose to adopt the name Tabaka independent of any marriage to him, yes?
Yes, in 2011.
In 2015, a final custody order entered in your matter resolving the custody case you had filed in this court system. Is that accurate?
It is not accurate. It was a temporary order.
Where on the order does it reflect that it's a temporary order?
I believe it's on the first page.
Your Honor, am I able to share my screen? Ms. Tabak, I'm showing you, I believe, the order that you are referring to that entered in 2015. And I'll direct your attention to the title of it, which is Order for Custody, Support, Parenting Time, and Preschool Daycare. Does that say that it's a temporary order?
3 lines down, if you look, it says temporary.
Well, it says, what it says is this matter having come before the court on plaintiff's motion for temporary custody and parenting time, the parties having an opportunity to work with counsel and negotiate a settlement as to the issues of custody, parenting time, and preschool, and placing that settlement on the record, this order was entered, correct?
The order was entered, yes.
Pardon?
Yes, the order was entered.
Right, the order was entered. And Your Honor, just for the record, I would state that the Register of Actions reflects that a motion for temporary custody and parenting time was pending. And the record, actually I can show it right here. The Register of Actions states that the hearing was held and the motion was dismissed because it was resolved by a consent order. And
Your Honor, I guess, is this testimony or is this an exhibit? I guess I object to the testimony from the attorney.
I would just ask the court to take judicial notice of its file. And so I don't think I'll offer it as an exhibit because it's part of the court record.
Well, I don't know. I haven't seen it as an exhibit.
Well, the court will take judicial notice of its own file, so.
Okay, thank you, Your Honor. All right. Ms. Tabaka, despite your characterization of this as a temporary order, would you agree with me that it's nonetheless an order of the court?
Absolutely.
And would you agree with me that you've never, up until after the time you were show caused, you have never petitioned the court to change this order in any way, shape, or form, other than child support?
That is correct. There have been no motions to change this.
Okay.
For reasons.
Well, I just want to know if you have or have not motioned the court to change this order since 2015 up until the time you were show caused. You have not, right?
I don't believe so.
And I'll now direct your attention to the parenting time provisions in the order, which begin on page 3, and specifically to the highlighted passage, which says defendant may take the children for afternoon parenting time and the younger minor child for morning parenting time, and both children on Fridays, subject to provisions stated herein, during such a time as plaintiff is working, so long as plaintiff is advised of defendant's plans in advance. You agree with that language?
Yes, I agree that it's written in the order that way.
And it says it under week 1, parenting time, and it just repeats the phraseology under week 2. Were you working when this order entered?
I was working a specific job with the department that had very specific hours in 2015.
And just for the sake of moving the hearing along, if it's a yes or no question, I'm just asking for a yes or no answer. And then, of course, if your attorney wants you to expound on anything, he's free to do that in your direct examination. So you were working full-time when the order entered, yes?
Yes.
And you had hours from Monday to Friday?
Yes.
Do you recall what those hours were?
8 to 4.
Was Chris working at the time this order entered?
Chris was working intermittently for multiple employers at his leisure when he felt like it or when he was called to work.
So he could make it so that he was available for the children while you were working, isn't that correct?
Or have somebody else watch the children while he worked.
Well, I didn't ask you what actually happened. I asked you if he was able to do that. He was able to make himself available if he wanted to for the children when you worked, right?
Yes, ma'am. He was, well, with my first statement.
It's a yes or no.
I'm sorry, but it's not, it's no, because sometimes he wasn't. That is not correct. No, not at every time. I had to hire daycare many times because he was not available.
Ms. Tabaka, I didn't ask you what actually happened. I'm just asking the simple question. You said that he could work whenever he wanted and he worked intermittently. And my follow-up question was, therefore, he was able to make himself available if he wanted to for the children. I didn't ask if he did that every single occasion. I just asked you if that was the case back then, that he could do that.
Your Honor, I think she answered the question, no. So I think it's a proper answer.
Well, I don't know. She went into a description of everything. I don't know if she answered it yes or no. So maybe we get that on the record and then we can proceed.
Sure, sir. No would be the appropriate answer.
He was not able to arrange his work schedule to take care of the children while you worked?
Correct, not at all times.
All right. And when this order entered, this provision was by a mutual agreement between the two of you. Is that accurate?
Yes, it was, yes, between the attorneys. Mhm.
Well, you read it and agreed to it on the record, correct?
Yes,
So you agreed to the provision. Isn't that a fair statement?
I agreed to a provision that ended up being in the court order in a way that didn't clearly define what its intention was.
Well, regardless of whether you believe the order clearly defined it, the two of you entered into a pattern over the next 6 years of Chris taking the kids while you worked, for the most part, correct?
No,
It is not your position, it is your testimony today that you did not enter into a pattern of Chris taking the children and caring for them while you worked?
That wasn't the question, Your Honor. The question was whether they did that for the 6 years. And so it's a different question here.
Well, clarify, Ms. Elaine, so we get the answer.
I will, Your Honor. Ms. Tabaka, from 2015 to the summer, would you agree with me that in the summer of 2021, there was a change in the way this provision was effectuated between the two of you?
yes,
All right, so from 2015, when the provision entered, to up to that change time in the summer of 2021, would you agree or disagree that you and Mr. Tabaka exercised that provision in a mutually agreeable way?
no,
And how was the provision exercised in an unagreeable way to you?
it was at his discretion. I often had to take off work to watch the children on a normal work day because he was not available or had other things that he was doing to watch the children. So it was variable through those years.
Okay, well, let's go back to the order if we can really quick and just take a look at that provision again. It says the defendant may take the children for the parenting time, right? It doesn't say that he has to, it just says that he may. Would you agree with me?
I would agree that may implies a possibility, yes.
All right, so the fact that at times you worked and he didn't take the children wasn't a violation of this provision, is that correct?
Can you please ask the question again?
Sure. If Mr. Tabaka did not take the children while you worked, he wasn't violating that provision, right?
Correct.
In fact, you were the only obligor in that provision. You were the one who had to allow him to have the parenting time if you were working. Would you agree with me there?
No.
For the record, Mr. Schaefer seems to be shaking his head to provide an answer to his client.
Well,
Your Honor, I will object to the question because the whole thing is not there. And she said, no, it is not consistent with who's the obligor. There's some obligations for both people in that order, and the order is going to read for itself.
well, the order will speak for itself, but I think the question was appropriate. So ask it again, Miss Elaine, and then the plaintiff can answer.
Thank you. Ms. Tabaka, it was your obligation to provide the children to Chris if he wanted to take them while you were working. Would you agree with me on that point?
May I answer this in not a yes or no question, Your Honor?
Well, you can explain yourself, ma'am.
He may watch the children while I am working, so long as he advises me of his plans in advance. That was what the obligation was in that notation, because I had to provide that data to the preschool to schedule the children each week ahead of time.
Ms. Tabaka, was this provision ever implemented one single time after both of the children exited preschool?
Can you like be more clear in your question? I'm confused.
I can try. After the children were both out of preschool, did Chris ever take the children while you were working?
Yes.
So what does you having to notify the preschool have to do with anything? Because you operated under this provision for years after the children left preschool, correct?
Actually, we operated under civil co-parenting unrelated to that provision.
I don't know what that means. My question was, did you operate under this provision after the children left preschool?
No, we operated under our own civil co-parenting agreement because circumstances had changed when the children left preschool.
Is it your testimony then? Because I think you said something different just a few moments ago, so let me be clear. Is it your testimony that you never operated under this provision after the children were both out of preschool?
This provision never came up ever until 2021.
So Chris never watched the children while you worked from the time the children left preschool to 2021?
No, that is not true.
So explain to me, please, how this provision was never operated under since the children left preschool.
Because that provision, if you read it, is talking about specific days and specific times. It refers to the older minor child, the younger minor child, and it's all relation into when the older minor child was in preschool during these days, the younger minor child was in daycare during these days. So to say that we operated under that provision when they left preschool, no, because it was no longer geared towards what it was intended, which was their preschool schedule.
Well, did you do some semblance of operation where Chris would still continue to care for the children when you worked, even though you would now like to say it wasn't because you were complying with that?
I believe the order says as long as the party can agree, then we can agree to things. So we had a civil co-parenting relationship that was established and existed for several years. And it was really not related to that provision. It was just between Chris and I, but it was not related to that provision.
Did you ever, is there any email message, text message, or any other communication that you can show the court that you said, okay, now that the children are both out of preschool, we're not doing this provision anymore?
No, because to me, that would have been a hostile remark to make to my ex, which would have put me in a bad situation with him.
Just like the hostile remark you made in June, where you told him you would no longer operate under that provision?
That was not a hostile remark.
But it would have been hostile when your children left preschool for you to say you're no longer operating under that provision, but you can still see them because now we're operating under civil co-parenting?
Sure, because everything is circumstantial. There was no reason to say such a thing when the children left preschool. Again, we were able to have civil co-parenting for many years. And then due to circumstances brought upon by the defendant, that changed and unfortunately destroyed the civil co-parenting that we had between each other for many years.
Well, let's fast forward to that then, Ms. Tabaka, since you said that when the children left preschool, there was no reason to say such a thing to him, but there arose a reason to say such a thing in June 2021. What did Mr. Tabaka do that was so egregious that it justified you terminating his ability to see the children while you worked and provide them the care that he had been providing to them?
Your Honor, I think that's a question, and it's hard to explain all the facets of the question. I would object to the form of the question. It's taking certain things into assumption which are not accurate, so it makes it difficult to answer the question.
Well, I guess based on what the question is, he's simply saying what happened in June of 2021 that again would cause him to change that agreement. I don't see that she can't answer that.
Yep.
Sure, Your Honor. In 2021, the father of my children utilized Child Protective Services in an illegal way to try and take immediate custody of my children and put me in a great position of hardship, mentally, emotionally, financially. And there had been a history of abuse in this relationship to begin with, but this exacerbated it. And so for the welfare of myself and the children included, because of how uncomfortable things had become between their father and I was essentially flexing schedule to be able to wake the children, bring them to school myself, so that we weren't having this unnecessary child exchange in the morning before school, where I had to be in the presence of a man who was trying to hurt me and take my children from me. And so it alleviated a ton of emotional trauma, being able to go from home to school, and in the opposite, going from school to home. I should not have to, especially on my own parenting days, have to see the father of my children who is deliberately abusing me if it's not necessary, because it causes me physical and emotional stress, and it also causes a tremendous amount of stress to the children when he and I are even in the vicinity of one another, because they don't know how to act. They're afraid if they come to me that there's going to be repercussions by their father for showing emotion towards me. And I wanted to eliminate those awkward situations for the children.
All right. So in other words, Ms. Tabaka, to put that more succinctly, once Chris made a complaint about information he had, and correct me if I'm wrong, information he had that your current then boyfriend, Kyle Gallus, had abused Daniel, one of your children. Once he brought that to light, you decided that he should no longer care for the children during the times that you worked, correct? For all the reasons you just stated, it was too hard on you, you didn't want to be in the same space with him, et cetera, et cetera.
Actually, ma'am, it was a series of events. It was multiple calls into Child Protective Services, false claims that were all denied or rejected, and then this final one where he submitted an ex parte to actually have the children taken away from me. That ended the civility. That put me in a position with this man, knowing that his intentions to harm superseded the welfare of the children. And because of that, I decided I'm not going to put us in the presence of the father that's trying to do this in unnecessary times during my parenting time.
Would you agree with me, Ms. Tabaka, that when an order says that the father can have the children when you work, and when you are working, that is then not your parenting time, that is the father's parenting time?
Madam, it doesn't say can, it says may, and that is with advance notice of his plans.
When you say advanced notice of his plans, what do you mean by plans?
What he intends on doing with the children during my parenting time.
Well, where does it say that in the order, that he has to tell you what he's doing with the children during your parenting time?
Plans, I believe, is the word that would imply that.
So he must have, all those times that he picked up the children, took them to school, took them to daycare, took them to preschool, picked them up from those activities, all of those times, he told you what his specific plans were while he had the children in his care?
He had to advise me of his plans. I've already mentioned this once before, but so that I would have that information to provide to the Child Development Center a week in advance of the children attending, so that they could schedule and have appropriate staffing and also be able to bill me properly.
Okay, well, that sounds like he had to tell you he was going to have them, not that he had to advise you of what he was going to do with them when he had them. You didn't tell the daycare what Mr. Tabaka was going to do with the children once he had them, correct?
I didn't tell the daycare that, but the note that you are bringing up to bring this case does imply, it does say plans. It does say plans.
Isn't it true, Ms. Tabaka, that was never exercised? Your newly found interpretation of the word plan was never exercised in those 6 years. He didn't tell you on a routine basis every day what he was going to be doing with the children. Would you agree with me?
I would agree that we never really operated under that provision at all, because we had a civil co-parenting relationship during that time. But that is how the order is written.
Well, it says plan, and by plan,
plans.
The order means he had to tell you he was going to take the children, right?
That's not how I perceive it. It says plans. Notify me of his plans.
And isn't it true, Ms. Tabaka, that the two of you had an understanding that was reached when you had this provision put into an order that got entered with the court, that every time you were working, he would take the kids? Isn't it just that simple?
Actually, it isn't that simple. That order or that provision or notation was something that was discussed during the child support end of everything. And it was because Christopher did not want to pay any additional child support. So it was decided, okay, we'll limit your child support obligation by allowing you to be the person to watch the children instead of paid daycare. But he needed to advise me if he was choosing to do that, because I had to advise the Child Development Center if he was not going to do that, so that they would be ready and have staff there to watch the children when he did not feel like watching the children.
It wouldn't be unreasonable for it, would it, for a parent to say, why should we pay for childcare when I'm available to take the children? You're making it seem like that was a negative thing that he thought or said.
No, ma'am, I didn't at all. I was completely fine with his with him deciding that he would prefer to be the daycare over having more child support assessed upon him. I didn't care so much about what he was going to be assessed in child support, but it mattered to him very, very much. And that's why he wanted it written into the order that he could be the daycare instead of paid daycare. And it could have been worded better by the attorneys in 2015 in preventing this from being an issue today. But that is the reason that exists, so that he could be the person in lieu of paid daycare, which would then be assessed into his child support.
Ms. Tabaka, did you and Chris ever have a disagreement up until June of 2021 about how that provision was to be interpreted?
Ma'am, we never referred to that provision ever in all the years since the order until Chris brought me into court.
So the answer is no. If you never discussed it, then you never had a disagreement about the interpretation of it, correct?
Correct. We operated under a co-parenting civility. We worked together pretty well from 15 all the way up until about the time Chris met his current wife.
And you never disagreed. I take it because you said you never operated under that. You never disagreed on how it was to be implemented.
I don't know what you mean.
Was there ever a time when Chris said, I'll pick up the kids as normal, or drop them off to me before school and I'll make sure and get them there because you're working? And you said to him, wait, you didn't tell me your plans with the children. You can't have them.
No, because that wasn't part of our civil co-parenting at that time. We did have routines, and to be honest with you, I tried to keep those routines as consistent as possible for the welfare of my children, despite when things were rocky between us, because they are, and they always have been. But what he did in 2021 by essentially illegally using Child Protective Services to try and take the children away, took it to a level where he essentially destroyed that civil co-parenting that we had. And
okay,
Ms. Tabaka,
yeah. Can you tell me, just for my own edification, where in anything is it shown that Mr. Tabaka was trying to take the children away from you?
Oh, I believe that would be the motion that he sent to Judge Kirkham while he was represented by Attorney Toth.
Well, wasn't that motion to prevent contact between the children and Kyle Gallus?
No, ma'am. That motion asked that the children be removed from me immediately, and the Kyle Gallus part was secondary.
Well, the Kyle Gallus part was primary because the allegation was that he had abused Daniel, correct?
I don't know which came first in the motion since it was 2 years ago, but he did specifically ask for the judge to take the children away from me immediately.
All right. How much during a typical summer before the summer of 2021 would Mr. Tabaka have the children during your parenting time because you were working?
I did not keep track of that. When he had other women watching the children, I have no idea.
I didn't ask about who else was watching the children. What I asked you was how often would he be watching the children while you were working? How often, let me rephrase it. How often would the children not be in your care because you were working, but they had been delivered to their father?
I don't have the answer to that because they weren't always going to their father, madam. They were going to their grandparents quite often.
So the court will rely on Mr. Tabaka's memory of that if he has a better one. How about when the children were sick and you had to work and they were unable to attend school? Were there times that Mr. Tabaka parented them?
Yep, and there were also times that I did as well. Generally, it depended on whose parenting day it was, madam.
Well, I'm talking about your parenting days. Your parenting days when you were working and the children, if one or two of the children were sick, were there times Mr. Tabaka cared for them?
It's possible. It's possible. I'm not going to say that it isn't, but I also cared for the children on my parenting days.
I'm not asking you that. All right. I understand you've parented the children. You have parenting time. What I'm asking you is while you worked, those are where my questions are. While you were working, were there times that Chris parented the children if they were sick? I think your answer was there were. How about when they had a day off from school and you were working and it was your parenting time? Were there times that Chris parented them?
That's absolutely possible. Again, it was variable.
Where do you work?
I work for the Calhoun County Sheriff's Office.
And when did you start working there?
January 2011.
Do you have the same position there as a bookkeeper that you had in 11, or have you changed positions during your time?
I changed positions.
What were you doing in late 2015 when this order entered?
In 15, I was still doing records and reception.
And when did that change?
Oh, maybe 2017 or 18.
And what was the change in 2017 or 18?
I was asked to accept a position in civil process of the sheriff's department.
All right. Did you have any other job changes after that?
I moved into a temporary position as bookkeeper for a retired bookkeeper for approximately a year, maybe a year and a half during COVID.
Do you remember which year or year and a half? Just approximate is fine.
I want to say that coworker retired in 2019, so it would have been 19 through sometime in 2021, maybe. I'm not sure.
And then what was your next position after that temporary position?
I was put back into civil process.
And do you remember approximately what month and year you were put into civil process again?
Early 2022, maybe.
Did all of
I
these,
was,
go ahead.
As a bookkeeper, we can all cover each other's work. So I'm still considered a bookkeeper, whether I'm bookkeeping or if I'm doing civil process.
So you have two jobs, essentially, two job descriptions.
I have whatever my boss asks me to do, but my position is called bookkeeper.
When did Daniel leave preschool for the judge's knowledge?
What year?
Yes.
Oh, I don't remember.
You don't remember what year your son would have gone from?
No, I don't remember what year my son left preschool.
Okay. As part of any of the positions that you just listed off at your employment, were you permitted to work from home?
Yes.
And were you always permitted to work from home, or was work from home an option that became available as a result of the pandemic?
The pandemic allowed for all of us to be able to do that, but it was an option prior to that as well.
Was it an option you exercised?
Not frequently.
Is it generally true then that you would be an in-person worker up through the pandemic until the time the pandemic began?
Yes, it's a much more effective way to get my job done, to be at work.
And when remote became an option, just take us through, did everyone go remote as a mandatory matter at the beginning of the pandemic, or were you still permitted to go in person as essential workers, or how did that work?
It was mixed because we still needed people in the office on days to take phone calls. So I don't remember the specific schedule arrangement, but I'd be in the office 2 days a week. Another coworker would be in the office 2 days a week, and another one would be there on such a day or such a day, so that we had phone coverage. If people were calling, they could still get service from the sheriff's department, but limit the amount of people within the building.
And did that change as the pandemic waxed on?
That remained in effect until county administrators opened it back up, and I don't remember the specific date of that.
When they did open it back up, did you return to work mostly in person?
Yes, I would say that I did.
Was there ever a time where the county was able to route phone calls to those of you working remotely?
Yes.
And that's part of your job?
Yes.
I'm going to show you what I would propose as defendant's exhibit A. Your counsel has a copy of this exhibit. Let me just change my margins here so that everything gets shown. Were you able to take a look at the exhibits that we submitted?
Yeah.
All right. So do you recognize these as your timesheets for your work?
Yes.
Okay. And as far as how these timesheets are created, do you have a program online that you use to create the timesheet?
County administration creates the timesheet and sends it out to all the county employees.
So how does the administration know what to put for you?
I list the hours that I work, and then it's provided to my supervisor, who verifies everything before signing off and submitting it.
And in fact, it's your signature on the timesheets that I'm looking at, right? Not a supervisor.
Supervisor is supposed to sign all of these. I am unaware of the unsigned ones or why they wouldn't be signed.
And I'm not so concerned about that aspect, but just wanted to confirm with you that you have a chance to review these timesheets and then before you sign off on them, correct?
Yes.
So you submit your hours to administration enters it on this form, then they send you the form, you review it, you sign off. Is that how it works?
No.
Okay.
I fill out these forms, then I sign it and I give it to my supervisor, who then reviews all of the time on there. If they have any discrepancies, they come to me and I fix them. And then a supervisor enters them into an HR portal system for submission, and then they retain a copy.
Gotcha. So you initiate this form. That's why I asked you at the very beginning, is there something, a computer system where you're entering this time? And you said admin does it, but you actually enter this time on this sheet that we're looking at.
I enter the time onto the sheet that admin provides us, correct?
And the comments that are in the comment section are your comments that you add?
Correct.
And then on each of the timesheets right above your signature, there's a line that says, I certify that all hours reported on this sheet are correct and complete as reported. And do you stand by that today, that all the hours and comments and information that you placed on your timesheets was true and accurate?
Absolutely.
When was the first time you clocked in hours in the middle of the night?
That probably started last year.
And does the county have urgent bookkeeping matters in the middle of the night, or what are you doing working at 2 a.m. or 4 a.m.?
Oh, so many things. Billing, processing out served papers that our process server has completed, making sure those proofs of services are getting to the attorneys or respective places they need to get to on a timely manner, entering new services that are received basically 24 hours a day, 7 days a week through email or mail, to which the abundance of these services right now is almost more than one person can handle. And so whatever isn't completed during the day, I will come in the middle of the night and I will get my work done so that it does not infringe in the process, in the legal process, postponing things that need to get done in other people's lives.
But you only decided to be that vigilant with your work after you stopped allowing Chris to have his parenting time while you were working, correct?
No, I worked any hours that I needed to, as long as I had my job, to make sure that my job is done timely.
But you didn't have that sort of work ethic before last year when you started working those sorts of hours?
No, ma'am, I have always worked whatever hours, or I've come in late in evenings if I felt there was something that needed to be done prior to a Monday.
Are you still angry with Chris about?
Hold on. If you could hold on a second, my staff just contacted me and they said they've lost everybody that's on this feed. So I don't know what. Okay. Why don't we take about a 10-minute recess? She's going to contact IT and see what's happening here. Hold on. Did you get it?